My name is Daniel Ashworth, and I am 38 years old. 2 weeks ago, I buried my mother, and I thought grief was the only thing I had left to survive. I was wrong. The funeral home smelled like lilies and carpet cleaner, a combination I will never be able to separate again. My sister, Renee, stood beside me at the graveside in a black coat that still had the department store tag tucked under the collar, and she gripped my arm like she needed it to stay upright. I believed her. I believed the shaking in her hands and the way her voice cracked when she read the eulogy I had helped her write at 2 in the morning, both of us crying over a laptop at my mother's kitchen table. 14 days later, on a Tuesday, Renee called me at 9:47 a.m. Her voice was different. Flat. Rehearsed. I talked to a lawyer, she said. I want half the house, half the accounts, and half of whatever Mom had in that investment fund with Raymond James. I think that's fair, Danny. I think that's what she would have wanted. I stood in my kitchen holding a coffee mug that had gone cold 20 minutes earlier, staring at the calendar on my wall where I'd circled April 9th, the day of the funeral, in red marker. 14 days. She had waited 14 days. Moms will already split things, I said. You know that. We read it together with Mr. Halloway. Wills can be contested, Renee said. I looked it up. That sentence, I looked it up, stayed with me for the rest of that call, and for a long time after it. Because it meant this hadn't been a moment of grief-fueled confusion. It meant somewhere between the graveside and the following Tuesday, my sister had sat down, opened a browser, and researched how to take from me. Before I tell you what happened next, and before I tell you what my mother had actually written in that will that Renee seemed to have forgotten about, tell me, what time is it where you're watching from? Where are you watching from? What's the weather like there? I'm curious how far this story will travel. I didn't answer Renee right away. I told her I needed to think, and I hung up before she could say anything else. Then I sat down at the same kitchen table where we'd written the eulogy together, and I let myself remember how we'd gotten here. Our mother, Carol Ashworth, was 69 when she died of a stroke on a Sunday morning in her garden in Lakewood, Ohio. She'd raised the two of us mostly alone after our father left when I was 9 and Renee was 6. She worked 22 years as a claims adjuster at a regional insurance company, and she never made more than $58,000 a year in her life, but she was careful with money in a way that bordered on ritual. She kept 3 savings accounts. She paid off the house on 4th Avenue by the time she was 54. She used to say, "A dollar saved is a decision you don't have to make twice." Renee and I grew up close, or so I thought. I was the older one, the one who fixed things literally, since I became an HVAC technician and then opened my own small repair company, Ashworth Climate Services, by the time I was 31. Renee went a different direction. She tried community college twice and didn't finish either time. She worked retail, then a call center, then nothing for almost 2 years after her divorce from her ex-husband, Tyler, in 2019. During that stretch, our mother paid Renee's rent for 14 months. I know this because I saw the Zelle transfers on Mom's bank statement once when I was helping her set up online banking. $850 a month, sent quietly, never mentioned at family dinners. I never resented that. I want to be honest about that part, because what came later would make people assume I was some bitter older brother keeping score. I wasn't. I loved my sister. I still do, somewhere underneath everything that happened. But love and trust are not the same account, and I didn't understand that distinction yet. What I did understand, sitting at that table with my coffee gone cold, was that something had shifted in Renee since the funeral, something that had maybe been shifting for a long time before that, and I just hadn't been paying attention. 3 days before Mom died, she'd called me. Not Renee. Me. She'd asked me to come by on a Thursday afternoon, and she'd had a folder waiting on the kitchen counter, the same counter where she used to do the crossword every morning with her reading glasses pushed up into her gray hair. Inside the folder were copies, not originals, copies, of her will, her account statements, and a handwritten letter in her looping cursive that I hadn't opened yet. I hadn't been ready to. "I want you to have this," she'd said. "Not because I don't trust your sister. Because I know you'll read it carefully, and she won't." I didn't fully understand what she meant by that until the following Tuesday, standing in my kitchen with the phone still warm in my hand from Renee's call, staring at that folder sitting exactly where I'd left it on my counter, unopened, for 11 days. I finally opened it that night. The folder held more than I expected. On top was a copy of the will itself, the same one Mr. Holloway had walked us through in his office 9 days after Mom died, the one where the house on Force Avenue, valued at roughly $214,000, was to be sold and split evenly between Renee and me, and the 2 savings accounts, totaling $61,300, were also to be split 50-50. That part matched what Renee already knew. What she seemed to have conveniently forgotten was the third item, the Raymond James investment account. That account held $118,400, and according to the documents in front of me, it had a named beneficiary designation that superseded the will entirely. Investment accounts with beneficiary designations don't go through probate the way a will does. Mr. Holloway had explained this to us both, slowly, twice, in that quiet office with the ticking clock on the wall. Whoever was named as the beneficiary got that account directly, no negotiation, no 50-50 split, regardless of what the rest of the will said. The beneficiary was me. I sat with that for a long moment, feeling something I didn't expect, not triumph, not relief, but a kind of low dread. Because now I understood exactly what Renee was trying to contest. She wasn't confused about the will. She knew about the Raymond James account. She wanted a piece of the one asset that was never supposed to be split at all, and she was dressing it up as fairness. Underneath the will copy was the handwritten letter. My mother's cursive slanted right, the way it always had since I was a kid watching her write grocery lists on the back of church bulletins. I want to share only pieces of it, because some of it isn't for anyone else. But there was one part one kept coming back to, over and over, in the weeks that followed. "Danny, I'm not leaving you more because I love you more. I'm leaving you the Raymond James account because you're the one who will use it to build something, and because I need you to be the one who holds the line when I'm not here to hold it myself." Renee has a good heart, but good hearts get taken advantage of, mostly by people who know exactly how far they can push. Don't let her push past what's right. Not for her sake. For yours. I didn't sleep much that night. I kept thinking about all the times growing up when Renee had borrowed money and never quite paid it back, $20 here, $100 there, I'll get you back Friday, that stretched into months. I'd never minded. It was small. It was family. But small things, I was starting to realize, are sometimes just early drafts of bigger things. 3 days after that first phone call, Renee called again. This time she wasn't alone. "I've got someone on the line with us," she said. "This is Marcus. He's my attorney." Marcus felt introduced himself in the clipped, over-polite tone of someone who does this exact call often. He told me Renee had concerns about the equitable distribution of the estate and wanted to discuss informal resolution before pursuing formal probate contest options. I wrote his name down on a sticky note, along with the date, April 25th, because something in me, some instinct I didn't fully trust yet, told me I needed to start keeping a record. "Renee," I said, ignoring Marcus for a moment, "did you know about the Raymond James account before Mom died?" There was a pause. Just slightly too long. "That's not really relevant," Marcus cut in. "It's relevant to me," I said. Renee finally spoke. "Mom mentioned it once. In passing. I didn't think it mattered." That was the first lie. I didn't know it for certain yet, not with proof, not with anything I could point to, but I felt it the way you feel a change in air pressure before a storm actually arrives. Something in her voice had gone careful in a way it never used to be careful with me. I told them both I needed time to consult my own attorney before saying anything further, and I hung up. Then I sat in my truck in my own driveway for almost 20 minutes, engine off, hands on the wheel, not driving anywhere. That evening, I called my mother's old neighbor, Diane Okafor, who had lived next door to us on 4th Avenue for 19 years and who Mom used to have coffee with every Sunday after church. I wasn't looking for legal help. I was looking for something else, some confirmation that I wasn't losing my grip on a version of my family that had maybe never fully existed the way I remembered it. Diane told me something I hadn't known. In the last year of her life, Mom had mentioned to her, more than once, that she was worried about Renee's new boyfriend and that she'd caught Renee going through papers in the house during a visit back in January, months before the stroke. "Your mother didn't want to make a big thing of it," Diane said. "She said she'd handle it her own way." I sat with the phone against my ear for a long time after Diane said goodbye, staring at the folder still open on my kitchen table, at my mother's handwriting, at the words "Don't let her push past what's right." I didn't know yet how far this would go. But I knew, sitting there, that I was no longer going to assume anything about my sister without proof. And 2 days later, proof started arriving, faster and worse than I expected. The proof arrived on a Thursday morning in the form of a phone call from Mr. Holloway's office. His paralegal, a woman named Priya Anand, told me that someone claiming to be acting on behalf of the estate had contacted the Cuyahoga County Recorder's office requesting copies of the deed to the house on 4th Avenue, along with a lien history. When I asked who had made the request, Priya hesitated, then said she could only confirm it wasn't me, and that the request had come in 9 days after the funeral, 5 days before Renee's first call about wanting half of everything. 9 days. Renee had gone looking before she ever picked up the phone to talk to me. I want to pause here and admit something uncomfortable. Part of me still wanted an innocent explanation. I called Renee that afternoon, and I asked her directly if she or Marcus had requested anything from the county recorder's office. She said no. Flatly, immediately, no hesitation at all. "Why would I do that?" she said. "I don't even know how that works." That was the second lie, and this one I could disprove, because 2 days later, Priya sent me, at my request, and with Mr. Holloway's approval since I was a named executor alongside Renee, a copy of the request form itself. It had Marcus Felt's law office listed as the requesting party, dated April 18th, with a note that the request was made on behalf of client R. Ashworth Colt. Renee had remarried in 2021, briefly, to a man named Kevin Colt, and though the marriage had already fallen apart by early this year, she still used the hyphenated name on certain legal documents. It was such a small detail, and it was the thing that broke something loose in me, the realization that this had been organized, deliberate, and running in the background for weeks before I even knew Renee was upset about anything. I drove to my mother's house that weekend, the first time I'd been back since the funeral. The garden she'd died in was still full of the tulips she'd planted in October, red and yellow, completely indifferent to what had happened to her among them. I stood there for a while. Then I went inside to start the process of sorting through her things, partly because probate required an inventory, and partly because I needed to be near something that still smelled like her, the lavender hand cream she kept by the sink, the smell that hit me every time I walked past that counter. In the study, in the bottom drawer of her desk, I found a manila envelope labeled in her handwriting, Renee, January 2026. Inside was a printed bank statement from Renee's checking account, the kind you'd only have if someone had given you online access or if you'd logged in yourself using saved credentials. There were 4 wire transfers, dated between November and January, from an account under Carol Ashworth's name to Renee's, totaling $9,400. None of which I had known about, and none of which matched the documented $850 a month arrangement from years earlier. Clipped to the statement was a sticky note in Mom's writing, 3rd time asking. Told her no more after this. She said it was for Ava's tuition. Called the school, no record of enrollment for spring term. Ava was Renee's 15-year-old daughter, my niece, and the idea that Renee had used her own child's education as the reason for pulling nearly $10,000 from our dying mother felt like something physically striking me in the chest. I sat on the floor of that study for a long time, holding that sticky note, feeling the particular kind of grief that isn't about loss anymore but about revision. realizing that the mother I'd been mourning had spent her last months quietly managing a problem she never told me about, protecting me from it, maybe protecting Renee from my reaction to it. I called the school myself the following Monday, Lakewood's Magnuson Academy, and spoke to the registrar, who confirmed, carefully and without much detail, that they had no billing record for a student named Ava Colt for the spring term. I didn't tell her why I was asking. I just thanked her and hung up. That night I made a decision that would define the next 4 months of my life. I wasn't going to call Renee and confront her with what I'd found. Not yet. I wasn't going to post about it, vent about it, or tell extended family before I understood the full shape of it. I opened a fresh document on my laptop and titled it Estate Timeline, and I started writing down every date, every dollar amount, every name, in order, exactly as I'd learned them. I also called an attorney of my own that week, not Marcus Felt's opposite number in some petty legal battle, but someone recommended by a client of mine, a probate specialist named Sandra Kwiatkowski, whose office was in downtown Cleveland. Our first call lasted 50 minutes, and by the end of it, she'd said one sentence that stuck with me for the rest of that summer. Whatever she's planning to claim, Sandra said, make sure you have more documentation than she does. In estate disputes, the person with the cleanest paper trail almost always wins, not the person who's loudest. I didn't know yet how much documentation I would end up needing. But I started building it anyway, one folder at a time, the same way my mother had built the one she'd left for me. Sandra Kwiatkowski's office was on the 9th floor of a building on Superior Avenue, with a view of Lake Erie that was mostly blocked by the building next door. I met her in person for the first time on May 6, 3 weeks after the funeral, carrying a folder that had already grown thick with printed bank statements, the recorder's office request, and photographs I'd taken of my mother's handwritten notes. Sandra was maybe 50, wore reading glasses on a chain, and had a way of looking at documents that reminded me of how my mother used to check tax forms, slow, unhurried, missing nothing. She read through everything twice before she said a word. Okay, she finally said. Here's where we are. Your mother's will is valid and was properly executed. I can see the notarization, the witnesses, the date. Contesting a will requires proving lack of capacity, undue influence, or fraud. Given what you've shown me, if anything, the undue influence argument runs the other direction. Meaning? Meaning if your sister tries to argue your mother wasn't of sound mind when she wrote this will, we now have documentation suggesting the opposite, that your mother was lucid enough to notice unauthorized withdrawals, contact a school registrar, and start keeping records of her own daughter's requests. That's not someone losing capacity. That's someone managing a threat. I felt something settle in my chest hearing her say it plainly like that. Not comfort exactly. Clarity. Sandra advised me to do 3 things. First, formally request a full accounting of the estate accounts through probate court, which would legally compel disclosure of all transactions in the year before Mom's death, not just what Renee volunteered. Second, preserve everything I had without altering it, including the original sticky notes and the manila envelope, in case authenticity ever came into question. Third, and this was the part that surprised me, she told me not to contact Renee directly about any of it anymore. Every conversation you have with her right now becomes potential testimony, Sandra said. Let it go through counsel. I know that feels cold. It's supposed to feel cold. That's what protects you. I filed the request for full accounting on May 9 through the Cuyahoga County Probate Court, case number PE 26-0417, the number I would end up memorizing over the following months the way you memorize a phone number from childhood. Marcus Felt's office had 30 days to respond with documentation. They came back in 19. What they produced surprised even Sandra. It wasn't just the 4 wire transfers I already knew about. There were 7 additional transactions I hadn't seen, dated between August of the previous year and February of this one, totaling another $6,150, moved from Mom's primary checking account into Renee's, always in amounts under $1,000, always with vague memo lines like gift or help. Renee's own attorney, in trying to prove Renee's financial need justified a larger inheritance share, had inadvertently handed us a documented pattern of exactly what Sandra called pre-death depletion, the kind of thing courts view very differently depending on who's asking for it and why. There was also, buried in page 14 of the disclosure, something none of us had been looking for, a $2,200 charge from a payday lending company called Quick Cash Ohio, paid directly from Mom's account in March, 6 weeks before she died, with a handwritten authorization letter attached that Marcus's office had submitted as proof Mom had willingly and knowingly supported Renee financially. The letter was signed Carol Ashworth. Except the signature didn't match. Not to my eye, and more importantly, not to Sandra's either. She'd handled enough estate disputes to know what a forged signature usually looked like: too smooth, too consistent, missing the slight rightward hook my mother's initial capital C always carried, the same hook I'd stared at 100 times in her handwritten letter to me. "I want a document examiner," Sandra said. "This is the kind of thing that either falls apart under expert review, or it becomes the whole case." I remember sitting in my truck in the parking garage after that meeting, engine off again, the way it had become a habit, some ritual pause I needed before driving back into my regular life, where clients were calling about broken furnaces and I still had to run a business while all of this unfolded underneath it. I thought about calling Renee. Just to ask her, one more time, human to human, whether she'd really done this. I didn't call. Sandra's voice was in my head, let it go through counsel. Instead, I opened my estate timeline document and added the new dates, the new dollar amount, the words possible forged signature, quick cash authorization, March 3rd. The document examiner Sandra hired was a woman named Louise Farrow, a forensic handwriting analyst who had testified in probate and criminal cases across 3 counties for over 20 years. It took her 11 days to produce a preliminary report. Her conclusion, in careful, hedged, expert language, was that the signature on the quick cash authorization letter showed significant inconsistencies in stroke pressure, letter forms, and pen lift patterns compared to 12 verified samples of Carol Ashworth's signature pulled from bank records, medical forms, and the notarized will itself. In plain language, it was very likely forged. I sat with that finding for a long time before I told anyone, even Sandra, how I actually felt about it. Not vindicated. Something closer to nauseous. Because forging your dying mother's name isn't a gray area financial dispute. It's a crime. And once Louise Farrow's report existed, I understood that this had stopped being only a probate disagreement between siblings, and had become something that could end up in front of a very different kind of judge entirely. Sandra called a meeting the following week, and this time she brought in someone I hadn't expected to meet in person. Detective Rosa Ifidez actually let me just write the name cleanly, no error, from the Lakewood Police Department's Financial Crimes Unit. Sandra explained that once forgery and potential elder financial exploitation entered the picture, this wasn't purely a civil probate matter anymore. Ohio law treats forged financial authorizations tied to a vulnerable adult's accounts as a criminal matter, and Sandra believed we had an obligation, both moral and strategic, to report it. "I want to be honest with you," Sandra said, sitting across the conference table from me with Louise Farrow's report between us. "Once we report this, you don't control the pace anymore. It becomes the department's case, not just ours. That can take longer than you want. But it also means you're no longer the only person saying this happened." I thought about my mother's sticky note, third time asking, told her no more. I thought about the tulips in the garden she'd never see bloom again. I told Sandra to make the call. Detective Marsh, a compact, unhurried man in his 50s who took notes in a small spiral notebook instead of a laptop, interviewed me for just over 2 hours on May 30th. He asked about the wire transfers, the quick cash letter, Diane Okafor's account of Mom's worry about papers being gone through, and the timeline document I'd been keeping, which I printed and handed over in full, feeling strange about giving away something that had started as a private way of holding myself together. "You did the right thing keeping this," Marsh said, flipping through it. "People don't usually have their facts this organized. Usually it's the other way around. We're trying to build the timeline for them. He told me the case would go to the Cuyahoga County Prosecutor's Office for review once his unit finished its own investigation, which included subpoenaing Quick Cash Ohio's records directly, pulling their internal notes on the loan application, and requesting the original ink-signed document rather than the scanned copy Marcus's office had submitted. Digital scans, Marsh explained, could sometimes hide alterations that showed up more clearly under a physical, high-resolution review. 3 weeks later, on June 19, Marsh called me directly. Quick Cash Ohio's loan file included something Marcus's office apparently hadn't anticipated becoming public, an internal note from the loan processor, a young man named Corey Baptiste, stating that customer's daughter Renee Ashworth Colt appeared in person, presented mother's ID, and completed signature on mother's behalf due to stated mobility issues. Corey had flagged it as unusual enough to note, but the loan had still been approved because Renee had brought mom's driver's license and a copy of a recent utility bill in mom's name. There it was. Not a rumor, not a suspicion pieced together from sticky notes and handwriting analysis, but a direct, dated, named admission from a third party that Renee had physically signed our mother's name to obtain $2,200 in payday loan funds 6 weeks before mom died, while, according to the medical records Sandra later subpoenaed as part of the probate accounting, mom had suffered no diagnosed mobility restrictions serious enough to explain needing someone else to sign for her. She'd been gardening in that yard 3 days before her stroke. I didn't call Renee. I didn't text her. I sat on my back porch that evening with a beer I didn't finish, watching the sun go down, feeling less like a man who'd won something and more like someone standing at the edge of a hole that kept turning out to be deeper than the last time he'd looked into it. My niece Ava called me 2 days later. She was 15, and she rarely called me directly, usually it went through Renee, or through group texts on holidays. Her voice was tight, careful, like she'd rehearsed what she wanted to say. "Uncle Danny, is Mom in trouble?" I did not have a clean answer for her. I still don't, if I'm honest, even now, telling this story. I told her that adults sometimes make decisions that have real consequences, and that whatever happened next wasn't her fault, and that I loved her no matter what came out of any of it. She was quiet for a long moment. She told me Grandma wanted her to have more because I needed help with school, Ava said. But there wasn't any tuition thing. I go to public school. I don't know why she said that. I felt something crack open in me that I hadn't expected, not new information exactly, since I already suspected the tuition story was false, but hearing it confirmed by a 15-year-old who'd clearly been carrying some quiet confusion about it for months. Renee hadn't just used our mother. She'd used her own daughter's name as cover, and Ava had noticed the gap between the story and reality long before any of the adults around her had bothered to ask her directly. That was the night I stopped hoping this would resolve quietly, in some private, dignified, family-only way. I called Sandra the next morning and told her I was ready to let this go all the way through, probate, the criminal referral, whatever came next, without flinching, and without protecting Renee from the consequences of what she'd built for herself, one small dishonest choice at a time, starting long before our mother ever got sick, and ending with a signature that wasn't hers on a piece of paper that should have never existed at all. The Cuyahoga County Prosecutor's Office assigned the case to an assistant prosecutor named Diane Restrepo, a different Diane than my mother's old neighbor, which caused enough confusion in my own notes that I started writing Restrepo and Okafor in different colored ink just to keep them straight. Restrepo's review took 6 weeks. In late July, she filed charges against Renee, 1 count of forgery under Ohio Revised Code 2913.31, and 1 count of theft from a person in a protected class, since our mother, at 69 with a documented cardiac history, qualified under the state's Elder Protection Statute enhancements. Renee was arraigned on August 3 in Lakewood Municipal Court and released on her own recognizance pending trial, with a court date set for late October. I did not go to the arraignment. Sandra advised against it, and honestly, I didn't think I could sit in a room and watch my sister be read charges without something in me breaking in a way I couldn't put back together before I needed to function for my own clients the next morning. Instead, I stayed home and worked on a furnace inspection for a family in Rocky River, and I found something strange and almost peaceful in the mundane, technical focus of checking gas pressure and igniter function while, across town, a courtroom clerk read my sister's name into an official record. The probate case moved on a separate but related track. Sandra used Restrepo's criminal filing, along with Louise Farrow's handwriting analysis and the quick cash loan officer's statement, to argue in probate court that the pre-death transfers to Renee, now totaling $17,750 across all documented instances, once everything was combined, should be treated as advances against her inheritance share rather than gifts, and that the forged loan authorization further supported removing Renee as co-executor of the estate entirely, a role she and I had technically shared since the will was first read. Judge Patricia Onyema heard the motion on September 12. Marcus Felt argued that removing Renee as co-executor before any criminal conviction was premature and prejudicial. Judge Onyema, reviewing the same documentation Sandra had shown her, disagreed. In her ruling, she noted that the standard for executor removal in this jurisdiction is significantly lower than the standard for criminal conviction, and documented evidence of financial impropriety toward the estate, independent of any criminal outcome, is sufficient grounds for removal under ORC 2109.24. Renee was removed as co-executor that day. I became sole executor of our mother's estate. I felt no satisfaction hearing that ruling relayed to me over the phone by Sandra's paralegal. I remember standing in my garage, surrounded by pipe fittings and a half-disassembled compressor unit, listening to the words sole executor and thinking about how many family dinners Renee and I had sat through as kids, splitting the last slice of pizza exactly in half because that's what our mother always insisted on, fairness measured down to the ounce, the dollar, the minute. I wondered when, exactly, that had stopped mattering to her, or if it ever had. Renee's trial date arrived on October 27. I did attend that one, seated in the second row of the gallery, close enough to see the back of her neck, the same haircut she'd had since her divorce, cut just above the shoulder. She didn't turn around once during the proceedings that I noticed, though I couldn't be sure, since I spent most of the hearing staring at the wood grain of the bench in front of me, listening. Corey Baptiste, the quick cash loan officer, testified first. He was younger than I expected, maybe 26, visibly uncomfortable being in a courtroom, and he answered questions in short, careful sentences. He confirmed, under oath, what his internal note had already said, that Renee had presented her mother's ID and completed the signature herself, citing mobility issues that Marcus's defense tried, weakly, to argue could have been a misunderstanding on Corey's part rather than a deliberate lie by Renee. Louise Farrow testified next, walking the courtroom through 12 comparison signatures on a projector screen, pointing out the pen lift pattern differences with a laser pointer, using terms like baseline consistency and letter form slant deviation that made the whole thing feel almost clinical, almost bloodless, describing something that had once been my mother's actual hand moving across actual paper. Then Detective Marsh testified about the broader financial pattern, the $17,750 in pre-death transfers, the false tuition claim, the timeline built from bank statements and Ohio Department of Education enrollment records showing no registration for Ava Colt at Magnuson Academy for spring term. Marcus Felt's cross-examination focused almost entirely on family dynamics, trying to paint the transfers as ordinary maternal generosity consistent with the earlier $850 a month arrangement from years before, and suggesting the forged signature might have been a one-time act of desperation rather than a pattern of exploitation. It was, I'll admit, a reasonably competent defense given what he had to work with. It just didn't have anywhere close to enough weight to move against what the prosecution had built, piece by piece, exactly the way Sandra had said it would, with paper, not with volume. The judge recessed for deliberation at 4:40 p.m. on the second day of trial. I sat in the hallway outside the courtroom on a hard wooden bench, drinking bad coffee from a vending machine, waiting to find out what would happen to my sister, and feeling, for the first time in months, something other than anger, a kind of exhausted, grieving stillness, like standing at the edge of water too cold to swim in but too still to look away from. The verdict came back the next morning, October 29, a little after 10 a.m. I remember the exact time because I was watching the clock on the courtroom wall more than I was watching anything else, the way you focus on something small and steady when the bigger thing in front of you feels too large to look at directly. Guilty on the forgery count. Guilty on the theft from a protected person count, with the elder enhancement provision applied, which under Ohio sentencing guidelines elevated it from a misdemeanor range offense to a fifth-degree felony given the aggravating circumstances Restrepo had argued. A documented pattern of exploitation against a person with a known cardiac condition, in the months immediately preceding her death. Renee didn't cry. I want to be honest about that, because I've turned it over in my head many times since, trying to understand what her stillness meant. She sat with her hands folded on the table in front of her, staring straight ahead at the judge, and she didn't turn around, and I didn't either, not really, though I caught the side of her face for a second when the bailiff said something to her quietly and she nodded. Sentencing was scheduled for December 8, 6 weeks out, to allow for a pre-sentence investigation report. In the meantime, Judge Onima's probate ruling from September stood independently. Renee remained removed as co-executor, and the criminal conviction now gave Sandra additional leverage to argue, in a supplemental probate motion, that the $17,750 in pre-death transfers plus the $2,200 fraudulently obtained loan, which the estate had technically been forced to absorb as a debt against Mom's accounts before anyone caught the forgery, should be formally deducted from Renee's share of the estate. Distribution entirely, rather than simply treated as an even offset. This is where I want to slow down, because this is the part of the story that people ask me about most when I tell it now. There was a family gathering already planned before any of this trial had concluded, my Aunt Colleen's 60th birthday, on November 8, at her house in Westlake, the kind of extended family event with cousins and second cousins and people who'd known Mom for 40 years and had heard, by now, some fragmented version of what was happening between Renee and me, mostly through the kind of low-grade family gossip that travels faster than anyone intends it to. I almost didn't go. Sandra hadn't advised for or against it specifically, the trial was over, the sentencing hadn't happened yet, and there wasn't a strict legal reason to avoid a birthday party. But I knew Renee would be there, because Aunt Colleen had specifically told me both of us were invited, and because Colleen, in her own careful way, had said, I think it's time this family sat in the same room again, whatever's happened. I went. I told myself I was going for Ava, mostly, since I hadn't seen my niece in person since that phone call in June, and I didn't want her to feel like the entire adult side of her family had abandoned her because of choices that weren't hers to make. Renee was already there when I arrived, standing near the kitchen island with a paper plate of vegetables she wasn't eating, talking to our cousin Beth in a voice pitched slightly too bright, slightly too performed, the way people talk when they're aware other people in the room might be listening for cracks in the performance. I hadn't planned to say anything to her directly. I'd told myself I'd be polite, brief, present for Ava, and gone within an hour. But Aunt Colleen, without knowing what she was doing, or maybe knowing exactly what she was doing, since Colleen has never missed much in her life, asked, in front of nearly everyone gathered near the dining table, so how's the estate stuff going, you two? Is it settled yet? The room went quiet in that specific way rooms go quiet when everyone already knows the answer and is only waiting to see who says it out loud first. Renee spoke before I could. It's basically over, she said, still holding that paper plate. Danny got everything. The lawyers took the rest. I felt something rise in my chest, not rage exactly, something colder and more exact than rage. Because it wasn't just untrue. It was untrue in a way clearly designed to make the room see me as the villain in this story one final time, in front of the last audience she had left who might not already know the details. That's not what happened, Renee, I said, and I heard my own voice come out steadier than I expected. You're not being asked to give up your inheritance because I decided to take it. You're forfeiting part of it because you forged Mom's signature on a payday loan 6 weeks before she died, and you were just convicted of it 2 days ago, in an actual courtroom, in front of an actual jury. I hadn't planned to say it that plainly, in that room, in front of Beth and Colleen and my Uncle Ray and 3 cousins I hadn't seen in over a year. But once it was out, I didn't take it back, and I didn't apologize for it, and I watched Renee's face change in a way I'd never seen before, not anger, not even embarrassment exactly, but something like the specific exhaustion of someone who has just watched a story they'd been telling themselves, and everyone else, finally run completely out of road. Nobody said anything for what felt like a very long time, though it was probably only 5 or 6 seconds. Aunt Colleen set down the serving spoon she'd been holding. Beth looked at her plate. My Uncle Ray, who has never in his life known when to stay quiet, said, "Wait, what?" Renee didn't try to argue the facts. That's the detail I keep coming back to even now. She didn't say I was lying, didn't ask for evidence, didn't demand I take it back in front of everyone. She just set the paper plate down on the counter, said, "I need to go get Ava," and walked toward the living room where Ava had been sitting with her cousins watching something on a phone. I found out later, from Ava herself, that Renee told her they were leaving because she wasn't feeling well, and that Ava, who is 15 and not stupid, had said, "Is this about what you did to Grandma's money?" in the car on the way home. Renee apparently didn't answer her. Ava told me this on the phone about a week later, in the same careful, too old for her age voice she'd used back in June. I stayed at the party another 40 minutes, mostly because Aunt Colleen pulled me aside into the kitchen and asked quietly if what I'd said was true, and I told her yes, and gave her the case number if she wanted to look it up herself, which she later did. She hugged me for a long time in that kitchen, and she cried a little, not dramatically, just quietly, the way people cry when they're grieving something that isn't a death exactly, but is still a loss, the version of the family she thought she had, maybe, or the version of Renee she believed in. Sentencing happened on December 8, as scheduled. Judge Onima sentenced Renee to 11 months, suspended to 18 months of community control, meaning probation rather than incarceration, given it was a first offense and the elder enhancement felony was at the lower end of Ohio's 5th-degree range. She was ordered to complete 120 hours of community service, pay $2,200 in restitution directly to Quick Cash Ohio to satisfy the fraudulently obtained loan, which the estate had already paid off to prevent collections action, meaning Renee now owed that money back to the estate itself under a separate probate repayment order, and she was barred, for the duration of her probation, from serving in any fiduciary or executor capacity for any estate or trust in the state of Ohio. The probate court finalized its supplemental order on January 14 of the following year. The $17,750 in documented pre-death transfers, plus the $2,200 restitution obligation, totaling $19,950, was formally deducted from Renee's share of the estate. Once the house on Force Avenue sold in February for $208,500, slightly under the earlier estimate, after some foundation repairs the inspection turned up, and combined with the remaining savings accounts, Renee's final distributed share came to $87,340, compared to what would have been an even split of roughly $137,850 each had none of this happened. The Raymond James account, worth $118,400 by the time it was disbursed, went to me directly, exactly as my mother had arranged, untouched by any of the probate proceedings, exactly as Sandra had told me from the very beginning it legally would. I want to be precise about something here, because people watching this sometimes assume the money was ever the point for me. It wasn't. I would have split every dollar evenly, gladly, the way Mom always insisted on with the pizza, if Renee had simply told the truth at any point along the way, if she'd called me and said, "I'm struggling, I need help, can we talk about this honestly?" instead of forging a signature and lying to a 15-year-old about tuition and telling a room full of family that I'd taken everything from her. Renee lost more than money, in the end. She lost her position as co-executor, which had been a kind of trust placed in her by our mother that she'd broken before Mom was even 6 weeks in the ground. She lost the ability to serve as executor for anyone else's estate for the next year and a half. She lost, at least for a while, the easy comfort of family gatherings, since Aunt Colleen's Thanksgiving that year was noticeably smaller, and noticeably quieter, and Renee wasn't there. And she lost something harder to put a number on, which was the specific kind of trust that Ava had in her, not gone entirely, because children don't stop loving their parents just because they've been disappointed by them, but changed, cautious. The way trust becomes once it's been broken and only partially repaired. Ava started spending more weekends at my place that winter. Not because anyone forced that arrangement. Just because she asked, quietly, if she could, and I said yes every single time. Spring came late that year in Ohio, the way it usually does, with snow still sitting in gray patches along the curbs well into March. I sold my mother's house in February, as I mentioned, and I remember standing in the empty living room the day before the closing, running my hand along the wall by the kitchen doorway where she used to mark our heights in pencil when we were kids, mine higher, then Renee's a few inches below, dated in her handwriting going back to 1998. I didn't paint over that wall before selling. I photographed it instead, on my phone, and I still have that photo saved, though I don't look at it often. Ava turned 16 in April. I drove her to get her learner's permit, since Renee was working a double shift that day at the call center job she'd gone back to after the community center service hours started eating into her schedule. It was a small thing, an ordinary Tuesday afternoon errand, but I remember it clearly because it was the first time in almost a year that something about our family had felt uncomplicated. Ava practiced parallel parking in an empty church lot for 40 minutes, cursing under her breath the way teenagers do, and I sat in the passenger seat laughing at her. And for those 40 minutes, none of the rest of it, the courtroom, the forged signature, the paper plate at Aunt Colleen's party, existed at all. Renee and I spoke for the first time since the birthday party in late May, almost 7 months after everything had come apart in that kitchen in Westlake. She called me, not the other way around, and she didn't apologize in the way I might have imagined wanting her to, months earlier, when I was still angry enough to want something clean and total from her. Instead she said, I finished my community service hours last week, in a voice that sounded tired more than defensive, and then she was quiet for a moment, and then she said, I don't expect you to forgive me. I just wanted you to know I finished them. I told her I was glad, and I meant it, though I noticed I didn't feel the old warmth rushing back in the way some part of me had once assumed it would if she ever said something like that. What I felt instead was smaller and more careful. Something like the beginning of a bridge being rebuilt, one board at a time, with no guarantee it would ever hold the weight it used to hold. We didn't talk about the money again. We didn't talk about the forged signature, or the quick cash loan, or the paper plate. I think we both understood, without saying it directly, that some conversations only work once, in a courtroom, in front of people whose job it is to weigh evidence and hand down consequences. And that anything we said to each other about it after that point would just be two tired people going back over ground that had already been settled by people more qualified than either of us to settle it. I started seeing Renee again at family things by that summer, Ava's 16th birthday party in April, a 4th of July cookout at Aunt Colleen's, careful, small doses of proximity. We were not close the way we'd been close as kids, splitting pizza slices down to the ounce. I don't know if we'll ever be that close again, and I've made a kind of peace with not knowing. What I do know is that Ava has both of us in her life now, in different ways than before, and that seemed to matter more to me, by that point, than whether Renee and I ever fully repaired what broke between us. I used part of the Raymond James inheritance to expand Ashworth Climate Services that year, hiring 2 additional technicians and leasing a second service van, something I know my mother would have approved of, given how she used to say $1 saved is a decision you don't have to make twice. I kept a small amount of it untouched, in a separate account, that I don't spend from. I've never fully explained to anyone, including myself, exactly why. I think it has something to do with wanting one part of what she left me to just exist quietly, unspent, the way her care for me had mostly existed quietly for years before I ever fully understood how deliberate it had been. I visit the cemetery sometimes, not on a fixed schedule, just when it feels right. I brought tulip bulbs there last October, the same variety she'd had in her garden, and planted a small row near her headstone without telling anyone I was doing it. I don't know if they came up this spring. I haven't gone back to check yet. Some part of me likes not knowing yet, the way you sometimes want to hold a small hope a little longer before finding out whether it grew. People ask me sometimes, when I've told pieces of this story to friends or to other clients waiting in their kitchens while I check their furnace, what I would say to Renee if I could go back to that first phone call, the one on a Tuesday morning 14 days after the funeral, and say something different. I've thought about that more than I probably should. And the honest answer is that I don't think there's anything I could have said that would have changed what she'd already decided to do before she ever picked up the phone. By the time she called me asking for half of everything, she'd already requested the deed records. She'd already forged the signature 6 weeks before Mom died. Whatever this was, it didn't start with that phone call. It started somewhere much earlier, in some private calculation she made about what she was owed and what she was willing to do to get it, long before grief ever entered the picture at all. I've also had to sit with my own part in this, uncomfortable as that's been. I keep returning to a question I don't have a clean answer for, even now. How much of what Renee did was shaped by years of us all treating her financial struggles as something to quietly absorb rather than something to talk about honestly, as a family, out loud? I don't say that to excuse the forgery. Forgery isn't a symptom of family dysfunction, it's a choice, made by an adult, with full knowledge of what she was doing and who she was doing it to. But I don't think you get to a forged signature on a dying woman's loan document without a long runway of smaller unaddressed things leading up to it, small debts never mentioned at dinner, a $850 a month arrangement nobody in the family ever discussed openly, years of Renee learning, maybe without even realizing it, that money moved quietly in our family, and that quiet was easier for everyone than honesty. That's not a tidy conclusion, and I'm not going to pretend it is one. Some people want these stories to end with the villain fully understood and the hero fully vindicated, everything sorted into its proper place. This one doesn't sit that neatly for me, even a year and a half out from the trial. I still love my sister. I still don't fully trust her, and I don't know if I ever will again in the way I did before that Tuesday morning call. Both of those things are true at the same time, and I've stopped waiting for one of them to cancel the other out. What I can say clearly, the one thing I've landed on with something close to certainty, is this: forgiveness is personal, and I think I've mostly gotten there, in my own private way, sitting alone in that empty house before it sold, or standing over tulip bulbs in a cemetery in October. But access is a different thing entirely. Forgiveness doesn't obligate me to hand someone the keys to hurt me again the same way. My mother understood that distinction better than I did, back when she was quietly building a paper trail I wouldn't find until after she was gone. She forgave things about Renee I never even knew she was carrying. But she also made sure the Raymond James account had my name on it, not because she loved me more, but because she knew exactly how far trust could be pushed before it needed a hard boundary behind it. Forgiveness is personal, but access must be earned back, slowly, deliberately, the same way it's lost. So I'll leave you with the question I still ask myself, some nights, more than I probably should. If someone you loved forced you to choose, in the space of a single call, between keeping the peace and telling the truth, what would you have done, if the truth meant watching someone you grew up splitting pizza with stand in a courtroom and hear the word guilty read out loud, because of choices only they had made? I don't know if there's a right answer. I only know the one I chose, and I know I'd choose it again. Thank you for watching. Everything in this video is fictional, made only for entertainment and reflection, and any resemblance to real people or events is coincidental. If this story meant something to you, I hope it's this: healing rarely arrives all at once, boundaries are not the same thing as bitterness, and choosing self-respect over easy comfort is sometimes the quietest, hardest, and most necessary decision you will ever make for yourself.